Good morning and good afternoon, and welcome to the Opioid Industry Document Archive's first ever national symposium. We're delighted that you've joined us today. My name is Caleb Alexander. I'm a practicing general internist and professor of epidemiology and medicine at the Johns Hopkins Bloomberg School of Public Health. And along with my colleague Kate Tasker from the University of California, San Francisco, I have the privilege of co-directing the Opioid Industry Documents Archive. For the sake of full disclosure, I've also served as a paid plaintiff's expert in federal and state opioid litigation. The Opioid Industry Documents Archive is a groundbreaking digital archive of documents arising from the opioid industry that advances understanding of the root causes of the opioid epidemic and helps address corporate behavior that is harmful to public health. Jointly led by the University of California, San Francisco and Johns Hopkins University, OIDA builds upon UCSF's more than 2 decades of experience housing industry documents, including the tobacco archives, which arose from the historic master tobacco settlements and which have fostered transformational discoveries driving tobacco policy in the United States and around the world. The Opioid Industry Documents Archive, or OIDA for short, contains 13.7 million pages of documents from 13.7 million pages from 3.2 million documents. The documents include emails, memos, presentations, sales reports, budgets, audit reports, DEA briefings, meeting agendas and minutes, expert witness reports, and depositions of opioid industry executives. While most of the documents in OIDA arise from select settlements or judgments, such as those from INSYS, Mallinckrodt, and McKinsey, don't be fooled. Within these and other OIDA collections, there is a wealth of important information about dozens of other corporate actors whose behavior has fueled the epidemic, including many other pharmaceutical manufacturers, as well as distributors, pharmacies, marketing firms, management consultants, and advocacy organizations. OIDA is also actively anticipating or preparing future document collections for ultimate disclosure, including a major document tranche arising from a settlement or judgment with Teva and Allergan. If you have yet to browse the archive, we welcome you to do so and to take advantage of a number of features to assist you in the process. In addition to introductions to the archive as a whole, as well as individual collections, we've developed other tools to support new users, including research guides suggesting specific lines of inquiry, complete with illustrative documents, as well as bibliographies, glossaries, and selected curated document and data sets. In the coming months, we will also be launching 2 new features. First, we've developed an interactive timeline that links documents within the archive to key inflection points in the epidemic, allowing for users to understand the connection between documents on the one hand and pivotal moments in the crisis on the other. Second, we are developing an image collection, which will present thousands of carefully curated images within the archives. The image collection will include key metadata to facilitate their browsing and use, and provide users with a highly interactive and alternative accessible entry point into the archives. We're also fortunate to have an incredibly experienced and talented team supporting this work. And if we can be helpful to you in understanding how the archive may serve your own needs, please let us know. The best way to contact us is through the information on our website. Before our keynote, I want to spend a minute thanking the many people who have contributed to the archive's existence and impact to date. As many of you may know, disclosure of documents such as these is the exception. It's the exception rather than the norm. And OIDA has arisen in part because of the overwhelming public interest in these materials and support for disclosure by the bereaved and others who have been personally impacted by the epidemic. I would like to take a moment of silence to acknowledge all such individuals, as well as the gravity of the events that bring us here today. I also want to recognize the vital role that attorneys general, individually and collectively through the National Association of Attorneys General, have played in making OIDA possible. Again, we would not be here but for the leadership and vision of our attorneys general and the incredible commitment of their teams, including many assistant attorneys general around the country. We are especially grateful for the close engagement with the offices of Minnesota, Massachusetts, New York, and Virginia, as well as the offices of the states of California and Maryland, where our home institutions reside. We thank you. I would also like to acknowledge the many other parties who are important to OIDA's breadth, depth, and ultimate impact, including the courts, private plaintiffs and counsel, OIDA's National Advisory Committee, researchers, journalists, the general public, and all of you. Finally, I'd like to thank Jason Chernesky, Kevin Hopkins, and Amanda Norman, who worked tirelessly to plan this symposium, as well as Kate Tasker, who leads UCSF's Industry Documents Library and who co-leads OIDA with me. I'd also like to acknowledge the incredible team spanning both UCSF and Johns Hopkins that continues to contribute to OIDA's remarkable and auspicious impact to date. I'd like to turn now to our speakers. Following our keynote, which will conclude at 1 p.m. Eastern Time, we will hear from 3 leading experts in the field. Our panel will extend from 1 until shortly before 2:30 p.m. Eastern Time, when I will have brief closing comments. Adam Koon, who will moderate our panel, is an assistant scientist at the Johns Hopkins Bloomberg School of Public Health. Adam's work draws on critical policy studies to understand the role of ideas, language, and social values in health policy conflict, and he has led a number of important and impactful studies using the archives. Aaron Kesselheim, our first panelist, is a professor of medicine at Harvard Medical School. A member of the National Academies of Science and duly trained in medicine and law, Aaron is the editor-in-chief of the Journal of Law, Medicine, and Ethics, the founder of the influential Program on Regulation, Therapeutics, and Law, or PORTAL, at Harvard Medical School, and a nationally renowned health law and health policy scholar. Regina LaBelle, our second panelist, is equally distinguished and director of the Addiction and Public Policy Initiative at the O'Neill Institute for National and Global Health Law at Georgetown University Law Center. Previously acting director of the White House's Office of National Drug Control and Policy, LaBelle is nationally renowned for her work focusing on identifying policies to reduce overdoses and using the law to promote access to quality addiction treatment, harm reduction, and recovery support services. I'd like to turn now to our keynote, the 30th Attorney General of the great state of Minnesota, and to provide you with information from Attorney General Ellison's biography. As the people's lawyer, Attorney General Ellison's job is to help Minnesotans afford their lives and live with dignity, safety, and respect. From 2007 to 2019, Attorney General Ellison represented Minnesota's 5th Congressional District in the U.S. House of Representatives, where he championed consumer, worker, environmental, and civil and human rights protections for all Minnesotans. Before being elected to Congress, Attorney General Ellison served 4 years in the Minnesota House of Representatives. Prior to elected office, he spent 16 years as an attorney, specializing in civil rights and defense law, including 5 years as executive director of the Legal Rights Center. As the leader of this public interest law firm, he oversaw a team of attorneys focusing on delivering justice for Minnesotans who had nowhere else to turn. He was also a noted community activist. Attorney General Ellison, we're so fortunate and honored to have you join us today. I want to thank you again for your interest and advocacy for document disclosure and for taking time out of your busy schedule to meet with us. We very much look forward to your comments. I will say for those of you joining us, while I have a few questions for Attorney General Ellison myself, should time permit, we also invite you to use the question and answer function in Zoom, and I will certainly review those and try to incorporate those for any discussion for time that remains after Attorney General Ellison's comments. So thank you again, Attorney General. The floor is all yours.
Thank you, Doctor. And I'm never too busy to fight for people who have suffered from this scourge. You know, it's an honor to be here, and I'm thrilled to see so many people deeply invested in the idea of transparency and to be part of a growing conversation around the value of transparency in promoting public health. I was part of the fight that led to the creation of the OIDA, the OIDA in 2021. And let me tell you, it's not easy, and it was not a foregone conclusion that we'd be here today. We can and we should celebrate that. Now, let me take you back about 111 years ago, back to 1913, when legendary Supreme Court Justice Louis Brandeis wrote a piece in Harper's Magazine called "What Publicity Can Do." The idea was simple. One that he'd been pondering for decades by that point, and one that he can be summed up best by one line that has stood the test of time. And that line is this, you probably know it. Sunlight is said to be the best of disinfectants. How many of us have invoked that phrase from Louis Brandeis? His article was an ode to the value of transparency, of not allowing misguided ideas of privacy to shield wrongdoers, or as he put it in his earlier writings, to allow them to, quote, pass themselves as honest men, unquote. No, we need to shed the light and allow the truth to come out and not allow people to hide themselves in some dark basement where wrongdoing can be hidden away. You know, and that's what the Opioid Industry Documents Archive represents. Sunlight, disinfectant, transparency, a disinfectant for deceptions of some very dishonest people and disorganizations, and a shield against future wrongdoers who might try to pass themselves off on that same crooked path. We can't talk about opioids without first reckoning with the human toll they've inflicted on this country and on every state and on every city and every rural community. From 1999 to 2021, almost 300,000 people died from prescription opioid overdoses, including nearly 10,000 people from my state in Minnesota. That number peaked at 130 Americans a day, which is still shocking no matter how many times I read it. And these numbers don't really cover all the emergency room visits, all the near misses, all the torn apart families, all of the out-of-home placement child protection cases, so much human damage. And now that the crisis that the drug companies have got rolling in the early 2000s has taken a new form, synthetic opioids like fentanyl have pushed the death tolls even higher. 112,000 people lost their lives to overdose in 2023, the highest total in U.S. history. In Minnesota, the crisis is not abating, sadly. In 2022 alone, there were 1,002 opioid-related overdose deaths, an all-time high. And these numbers only tell part of the story. Another important part of the story is its racial disparity. In Minnesota, Black people are 3 times more likely to die from overdose deaths than whites, and Native Americans are 10 times more likely to die. And this pattern has replicated itself all over the state and sadly all over the country. Nothing, no amount of settlement money, no amount of transparency can make up for the death and the devastation these companies have caused. Nothing can bring back those we've lost or restore families and communities that have been torn apart. And regarding the racial statistics, the racial disparities, don't be fooled. This is not a Black or Native American problem. This is an everybody problem. And people of all income levels and racial backgrounds and cultural communities have been very adversely affected. Back when I was fairly new at the job, and my job was in my office was going after Purdue, Insys, Malin Kroc, Johnson & Johnson, and others, I had a conversation with Dave Baker. You may not know Dave Baker, but I know him well because he's a Minnesota state legislator and a Republican. Dave and his wife, Mary, lost their 25-year-old son, Dan, to an opioid overdose a decade earlier. We were working on the potential terms of a settlement, and Dave told me, you know, you guys can argue about numbers all you want. He said, I don't care how much money they pay. It won't bring Dan back. Only one thing can make any good come out of this. And that's if these SOBs, that's what he said, can't do it again. And that goal has never left my mind, and it's never left our sights. And that's why we fought so hard for the creation of this archive. Yes, we landed historic financial settlements with pharmaceutical distributors and opioid manufacturers with dollar amounts reaching into the tens of billions. Those funds are now being used to combat the opioid crisis in Minnesota and across the country. While most of the press on the national opioid settlements focuses on dollar amounts, we all knew that no amount of money can ever make up for the death and devastation these companies have caused, even as we hold them monetarily accountable. But we also knew, as Judge Brandeis knew more than 100 years ago, that there was another way to reach justice in this case. Publicity, sunshine, disclosure, disinfectant. We felt strongly that any opioid settlement absolutely must include full transparency and disclosure of internal documents. And we had 3 reasons for that. Number one, we deserve truth. And that we includes all the families, including the family of Representative Dave Baker and all of your families and everyone you know. So, we deserve the truth, and we know exactly what these companies, so that we can know exactly what these companies did to our families, who did it, and so they can never do it again. So what truths do these documents reveal? They reveal companies engaged in widespread deceptive marketing of opioids. They failed to act as suspicious orders of opioids flooded communities. And as the tragic impact of opioid crisis multiplied year after year, these companies continue to twist the truth and to hide the damage they caused. The documents in this archive include things like this: clinical trial data and FDA communications that show how drug companies obtained FDA approvals and concealed abuse potential of opioids. Also, lobbying records that showed how these companies influenced lawmakers and regulators. Financial records that show how they curried favor with academics, trade groups, and health providers. Sales records that show how they pushed opioid prescriptions and distributed opioids in staggering volumes. Internal communications that show how they turned a blind eye to their role in causing the crisis, then blame the victims instead. The American people to know all of this. For example, we deserve to know how Insys Therapeutics paid doctors to push prescriptions for a substance, a fentanyl spray that was 100 times more potent than morphine. The Insys Speakers Bureau was supposedly a lecture series aimed at educating doctors about substance. In reality, most of these events were fake. Doctors would get paid thousands of dollars in speaking fees, but instead of putting on a slideshow presentations for other doctors, they'd instead go to lavish meals with their Insys buddies. Sometimes Insys even put forged signatures on phony sign-in sheets for speaking events that never happened. Lather, rinse, repeat for 3 long years and far too many tears. All of this was little more than a basic bribery designed to line the pockets of doctors willing to prescribe high amounts of substance. With help which helped line the pockets of INSIS executives, all at the expense of patients. In Minnesota, the only two doctors who prescribed substance at any real volume were paid tens of thousands of dollars for these sham speaking events. The archive has it all. Regional sales managers pushing their teams to direct speaker fees to their top substance prescribers, saying, quote, if your speaker does not have at least 20 patients on substance, they should not be booked to speak, unquote. The INSIS VP of sales emailing his entire sales force saying that the speakers bureau should be their, quote, single most important function, unquote, and that any sales rep whose speaker program numbers decline should be fired. And of course, a sales representative documenting the message they tried to get across to one doctor saying, quote, if she wants the lunches and to speak for substance, she needs to prescribe it, unquote. One New York sales manager put it to his team very simply, quote, no scripts, no programs, unquote. We deserve to see all of this, and this archive has it. The American people deserve to know how McKinsey consultants were advising both the opioid manufacturers and the FDA, working both sides of the system to help the drug company turbocharge their word, opioid sales. McKinsey advised Purdue Pharma to push its highest dose versions of OxyContin, even after Purdue had admitted to misleading doctors and regulators about the dangers of the drug. The company helped other pharmaceutical clients fight off government oversight and dodge accountability. All the while, McKinsey was also working with the FDA, helping the agency redesign the drug approval processes and pushing to weaken opioid safety programs. And not once did McKinsey disclose this obvious and troubling conflict of interest, not one time ever. The archive has it all. PowerPoint presentations advising Purdue on how to respond to FDA's plan to regulate OxyContin, debriefs from McKinsey partners worried about Purdue's bad publicity, and then not 2 months later, emails celebrating McKinsey's launch of, quote, Project Scottsdale, unquote, a series of plans for reshaping Purdue's business. And on the other side of the coin, a proposal to the FDA detailing how McKinsey could help modernize, that's their word, a euphemism if ever there was one, its systems for drug evaluation and research. The American public deserves to know how opioid manufacturer Mallinckrodt identified and targeted physicians who wrote outsized amounts of opioid scripts and worked to persuade them to choose their drug, Exalgo, over the competition. This was key to their strategy, motivating their sales reps with commissions for getting more prescribers on board and getting those prescribers to sign more refills. They even created playbooks. Again, they called them playbooks for their reps to follow, listing clinicians in their territory ranked by their prescription rates. And the archive has all of this stuff too. The playbooks themselves, for starters, and it's worth noting that top-ranking prescribers in each of them all ended up losing their licenses, penalized for shady practices, and getting indicted for their role in the opioid scheme. It's got emails from the press, from the sales representative saying to his managers how he plans to, quote, take his nice gloves off, unquote, and get more, quote, pleasantly aggressive in pushing doctors in his territory to prescribe Exalgo. It's got the communications to Mallinckrodt executives from doctors wanting to help the company, quote, validate the benefit of chronic usage of long-acting opioids. Incredible. Some of this is hard to read. The sheer greed and naked joy of these folks displayed as they willingly and knowingly ruined hundreds of people's lives. But they deserve to know. The people deserve to know. And as hard as it may be to revisit, it's also important that we know. Next, we got to improve our response. That brings me to the second reason why we push so hard to create this archive. Access to these documents will improve public health responses to opioid crisis and future crises, which we may not even be thinking about yet. I'm not alone in that belief. As we were working on a settlement, 35 historians of medicine and public health filed an amicus brief in the case. This group wanted to make clear that we needed sustained research into all aspects of opioid crisis, medical, economic, social, and cultural. They needed that very victim, that they argued, that every victim of the opioid epidemic was caught in a far-reaching web of circumstances. The power of the drugs themselves, the reach of effectiveness of the marketing methods, the inequities in our healthcare system, and the moral judgments our society makes on addiction. They knew that Dave Baker, the Minnesota state legislator I talked to you about, who lost his son to overdose, and they also knew that no settlement could hope to repair all of the harm done, but that access to information would help researchers untangle the web of circumstances that trap so many Americans so that folks in the future wouldn't get caught. And they were right. The information in this archive is going to influence and inform the work of scholars, journalists, regulators, elected officials, and voters. The sunlight we're shining on these nefarious practices is going to accelerate the shifting tide of scholarship and policies on opioids. And we're just getting started. The opioid crisis spanned 2 decades, and the archive is only 3 years old, but we're already seeing some seeds begin to sprout in the sunlight. Johns Hopkins has developed a curriculum library using archive materials. It provides teaching materials for undergraduates and graduate level courses, helping the next generation of leaders better understand the tactics of the opioid industry and that it used to power the opioid crisis, and giving them tools to create solutions. Journalists from New York Times, Wall Street Journal, USA Today, and others have taken deep dives into the archives. The stories they've produced on the misdeeds of the drug manufacturers have further amplified the sunlight that this archive creates. Without it, where would we be? Researchers and journalists know full well how difficult it is to get pharmaceutical companies to talk openly about their practices, and you can forget about getting anything on paper. It's invaluable that we have an archive of over 3 million documents instead of having to fight for scraps and rely on whistleblowers bound by bad faith non-disclosure agreements. The archive will advance our scholarship and our storytelling about opioids and the industries that push them on us. And mostly, it will protect the family of people like Dave Baker. We know this will work because it already has. In 1998, my legendary predecessor, still kicking, still going strong, Attorney General Skip Humphrey, friend of mine, friend of all, fought big tobacco to its knees. The state's 3-month trial exposed the industry's decades-long campaign to deceive the public about the dangers of smoking. On the eve of closing arguments, the tobacco makers agreed to settle to a settlement of over $6.5 billion. But that wasn't all. It required each of the companies to open up their internal documents to the public. 6 months later, a similar provision was put into the master settlement agreement that resolved the claims of 46 more states against tobacco makers. What's the result? Tobacco makers released 70 million pages of documents exposing the industry's methods of deception for the first time in history. Since the archive was established in 1999, it has been the foundation for hundreds of scholarly articles. One academic review concluded that, quote, few single events in the history of public health have had as dramatic effect on global tobacco control, unquote. It's not hard to understand why. Tobacco Document Archive helped to change public attitudes once people understood how they had been manipulated into smoking and deceived about its dangers. They were far more willing to support smoking reduction measures. In the last 20 years, smoking cessation efforts have saved thousands of lives and billions of dollars in worker productivity and medical costs in Minnesota alone. The Opioid Document Archive will have the same effect. And then the third thing is discouraging the next attempt. And here's the third reason, and here we go. This last reason where these folks, just like Dave Baker called them SOBs or any other ones who get the bright idea to try anything like this in the future, anyone, any company, any executive, any sales manager, anyone who's thinking about deceiving the public about a health crisis they've caused is going to have to think twice because of this archive. Why? Because they can see the names and the faces of those who tried before and now they will be exposed to the light of day. Because would-be troublemakers don't like the idea of being named and shamed. There's a school of thought that argued against creating the archive, saying it would provide a roadmap for future prospective wrongdoers, giving them a step-by-step guide on how to deceive consumers, pressure regulators, bribe professionals, and employ all of the shady tactics the opioid companies did. But I disagree. I think that the benefit of the sunlight far outweighs the risk of what it might reveal. I also think that anybody who wants to use opioid manufacturer playbook should remember, we've got the playbook too, and we know how to use it. We don't have to rely on hypotheticals to see how all this could play out. We've got a ready-made example in the tobacco companies and JHU Labs. After the landmark tobacco settlement, Minnesota led the nation in reducing tobacco use until JHU came along, the vaping company. The popularity of their vape products erased a decade of progress. They got real big, real fast, in part by following the example of the tobacco companies. They knowingly and deceptively lured a new generation into nicotine addiction. These are products with higher, more potent, and more addictive doses of nicotine than your average cigarette. But JHU still chose to market them as a safe alternative to smoking, and it was never safe. JHU played all the same old games. They played all the same old hits. Youth-focused marketing, different flavor options, false claims of safety. JHU's co-founder even said that before JHU launched its products, they studied Big Tobacco's marketing strategies in detail. And yes, those strategies were on full display in the tobacco archive, and we revealed that in the trial. But JHU also had to face justice. And when JHU chose a battle that Minnesota was ready to fight, they got exposed. We sued JHU in 2019 and later added Altria, their big tobacco investors, as defendants. We allege these companies violated multiple state consumer protection laws, breached their duty of reasonable care, and created a public nuisance in Minnesota. We made our case. We shared the documents that made plain just how closely JHU was working from Big Tobacco's blueprint. We even called expert witnesses who had testified in the tobacco case 25 years before. And just like the tobacco trial, on the eve of closing arguments, JHU said, are you willing to talk? And we said, sure, but you're gonna have to tell the truth and you're gonna have to pay. JHU agreed to settle. They had the tobacco playbook, but so did we, and the result was the same. Not only did Minnesota win the biggest per capita monetary settlement with JHU in America, not only did JHU agree to stop marketing to children, not only did they agree to accurately disclose just how much nicotine is in their products, but we also won some sunlight. JHU and Altria agreed to publish their internal documents from the litigation to a public document archive. That means we've got more material for important research, more stories to share on how these wrongdoers operate, and more tools to use the next time some company gets the bright idea to deceive customers. So in conclusion, these stories of the power of sunlight are encouraging, but there is more darkness to be brought to light. The sad truth is there will likely be a next time. There have been too many last times for us to believe otherwise. Before JHU, it was tobacco. Before opioids, it was lead, fossil fuels and climate change, social media and mental health. It's a shameful pattern of business putting their bottom line over human life, using lies to line their pockets at the expense of everyone else. And until we can cut that malignant instinct from our society, we have to use every tool at our disposal to protect each other. We all have a role to play. Attorney generals like me have a role to play. Researchers need to spot the trends and the patterns and in the data that can help us keep our community safe. Journalists and storytellers need to make sure people know that these companies what they're doing and bring them to light. And policymakers need to shape the rules that govern what these companies can and cannot get away with. And all of us need to be much better at our jobs if we're going to continue to advance the public interest. And sunlight will be our aid and our guide. That's what this archive is all about. And that's why it's vital. The human brain is pretty good at pattern recognition. And when we can all see the story laid out in front of us, we can spot it when it starts to repeat. No one likes to get played, and we especially hate getting played twice. So when the next set of wrongdoers comes along, this archive and others like it will make sure they can't pass themselves off as honest. We'll have enough sunlight to make sure there's nowhere new for them to hide, and hopefully get to the day when we drive out the darkness once and for all. So thank you all for listening, and I definitely appreciate your partnership.
Thank you so much, Attorney General Ellison. Your comments were incisive and compelling, and again, we really appreciate the opportunity. It's a unique opportunity that we have to be able to engage with you, and I do want to welcome those that are joining us. You're welcome to submit questions. There is one already that I may pitch to you, Attorney General Ellison, but for those of you that are joining us, this is your chance. We have 20 minutes or so with the Attorney General of the state of Minnesota, and this is a unique opportunity to ask questions about document disclosure. I'll begin with one about, whether there's a general trend towards greater document disclosure. Of course, attorneys general trade things for money all of the time. I mean, thinking about injunctive relief, for example, and document disclosure comes at the cost of larger settlements. And so, is it fair to say that this is an increasingly useful and important tool in the toolbox for attorneys general? And how likely do you think it is that we will see significant document disclosure focused on litigation, some of these other industries that we're talking about, whether fossil fuels, handguns, and so on and so forth?
The answer is yes. This is an increasing tool in the toolbox, but we've got to work together on this. When you all who are researchers, public health professionals and researchers, when you are advising lawyers and attorneys general, always tell them we got to have the archives. We must have the document disclosure. And I would say that just about every attorney general should absolutely consider a non-disclosure agreement a deal breaker. It's got to be a deal breaker, because what we know, Dr. Alexander, is if you don't agree to an archive and you do agree to a non-disclosure agreement, they're just going to keep doing it.
Right.
Sometimes they keep doing it even with those things. And so, these have got to be a part of how we challenge these major health harming products and services.
Thank you. And let me ask about privileged documents. I'm sure that you're aware that the Insys bankruptcy proceedings include a provision for the ultimate release of privileged documents between counsel and Insys executives. And while, of course, with Purdue, no decision has been made about anything. I mean, it sits with the Supreme Court. My understanding is that there has been at least some advocacy or some proposal that privileged documents from in that setting would also see the light of day. I'm not a lawyer, but I was always under the impression that what goes on between my lawyer and me is not going to see the light of day. So what are the rules of the road? What are the terms and in which how does making those public not undermine the concept of privilege, or what are the legal deliberations that you and your colleagues balance in arguing for the disclosure of patient attorney, not patient attorney, client attorney communications?
Well, privilege often is backward looking. So if you tell me about the facts that led you to be accused of the civil violation or the crime, that's privileged. And what we're in our trial strategy, our legal strategy going forward to defend your rights, that's privilege. But here's what's not privilege: a conspiracy to commit a crime in the future.
Right.
You can't do that. A conspiracy to commit a civil infraction in the future. To say, okay, here's how you skirt the law. That's of dubious value to the law and to the public interest. But again, I'm a firm believer in privilege. I think if you don't have it, your client can't really tell you the full story. But that's a lot different from saying what they're going to do going into the future. And lawyers are not supposed to be a shield for wrongdoing. They're supposed to be your legal advisor to help you manage your legal rights. So I would just say to lawyers, yes, you have a tremendous responsibility because you have a lot of power. When you should never let anybody engage you in how to advance, criminal or civil wrongdoing going forward.
Thank you. We have a few questions from the group that's joined us. I'm going to read this one verbatim so I don't butcher it. Attorney General Ellison, what are your thoughts on legislation to constrain discretion of judges and/or civil litigation parties to approve confidentiality terms as part settlements? Private incentives of parties, including plaintiffs, to maximize size and speed of settlement may not align with broader public interests. Some have even suggested that immediate incentives of judges to expediently process cases create incentives to approve confidentiality provisions in settlements that may not align with public interests.
Yeah, I recognize those to be real hazards, and that's why we've got to be vigilant. Here's the good thing about having attorneys general or other public lawyers involved in these cases. I'm not trying to add to a bottom line. I'm not trying to increase billable hours. All I'm trying to do is safeguard the public interest. And so I think that we should be on alert for these things repeating themselves if confidentiality agreements, non-disclosure agreements, and no archives are part of the settlement. I would say I think judges have a larger mission. And I think this is where citizens watching cases can play a big role. I mean, I think that it is important as cases are being litigated and settled that public health professionals and others say, Judge, we know you're considering this settlement. Here's how a quick, expeditious settlement to get this thing off your docket is going to negatively impact community. And I think 99 judges out of 100 will say that is an important thing to consider. And that's why, and so I think it's a matter of advocacy. And also, if the judge won't accept your paper, well, talk to him through the newspaper. That's what press conferences are for.
Fair enough. And so it sounds like you're not, legislation may not be necessarily the right way to constrain discretion of judges or civil litigation parties to approve confidentiality terms as part of settlements.
Well, I would not preclude legislation.
Yeah.
I just think that at the end of the day, a vigilant, on your toes advocates is what's going to keep the public safe. Right. But a bill couldn't hurt as long as it's carefully construed.
Right.
It's what I'm saying is more emphasis than one versus another.
Right. Okay. We got another for you. Might you speak about the role of attorneys general within this moment in history in association with the opioid epidemic and questions of transparency and accountability? Might you discuss the impetus for attorneys general to act and to do so somewhat collectively? What motivates you to think and act on behalf of those more vulnerable rather than to protect the powerful despite certain professional repercussions? For instance, you're also cognizant of the role of healthcare debt, which is garnering more attention, but still under-addressed.
Yeah, absolutely. Well, I think one thing that everybody should know is that it is the job, the mission, and the responsibility of the attorney general to be the people's lawyer. You're not corporate counsel for some corporation. And if you go into this job with that in mind, you absolutely don't deserve it. It is important for everyone who is voting on attorney general or voting for a governor who may appoint an attorney general. About 43 are elected, and the remainder are either appointed by the governor or, even in the case of Maine, elected by the state legislature. It is important as to who's going to sit in that seat. This person has got to be one who is willing to advance the public interest without regard to personal circumstances. If that's not where they're coming from, they don't belong in this job. And let me tell you, big industry pushes their candidates.
Right.
They do.
Right.
I can tell you that I've been in more than one campaign debate with somebody taking me to task because I sued a price gouger or a polluter or someone like that. I mean, this is how the game is played. So we've got to be active, right? And so I would also say that it's really important to meet with your attorney general. Well, here's the problem with being attorney general: you don't know everything. You don't know that many things. I'm certainly not an expert on public health. So, Dr. Alexander, I rely on people like you to say, hey, Keith, you need to keep your eye on this because this is coming down your way. Right. And there's something you could do about it. So I'd say everybody on the call should make sure that you try to get in like once or twice a year with your AG to just with a list. Here's what we think is important. Here's what we're seeing. Here's the effect on our patients, and so that we might be able to do something about it. And not everything is a lawsuit. Sometimes a letter will do. Sometimes calling parties together will do. Sometimes a lawsuit's necessary as well. But your AG, they are there to safeguard the public interest. And if they're doing otherwise, they don't deserve to be in that job.
Thank you. You spoke, you gave some really poignant examples from these documents, and almost fall out of your chair when you hear them. And it's part of the value of the archives. I was pleased that you provided us with that. There are documents in the archive that reveal shocking lapses in judgment and behavior on the part of industry actors, but it's exceedingly rare for individuals, not corporations, but individuals, to be held personally to account. So what is the appetite of attorneys general and their constituents for demanding greater personal liability among executives, for example, who played a key role in the companies that have fueled the opioid epidemic?
Well, I have a big appetite for it, but some of us are constrained by the law. So in Minnesota, in order for me to charge somebody with a crime, the governor has to appoint me, or the county, one of the 87 county attorneys has to ask me to do the case. I don't have independent jurisdiction to charge someone with a criminal offense. Now, I have pretty broad latitude in terms of civil laws, but not that much in the criminal. That's why it's important for your attorney general to be sitting down and meeting and have a very fluid relationship with people who have that criminal prosecution authority, including the U.S. attorney. The U.S. attorney has a fairly broad latitude on any kind of crime that might, cross a state line. And there are a whole bunch of statutes involving fraud and everything else. So I think that there's a way to do it. What we really do need is to stay in partnership with the advocates, and because the advocates might say, yeah, fine, let's sue the company, let's get injunctive relief, let's get some money back. But these 3 or 4 people, the main liars and deceivers and fraudsters, they need to answer and they need to be charged. And that can't happen. And the AG, even if the AG doesn't have the ability to charge the individuals themselves, can write a letter to the U.S. attorney and say, these people need to face criminal liability. And we do that in our office on a fairly regular basis. So that's another thing we should do. And we should keep all those tools at the ready to protect the public interest.
And so are the laws governing this different, highly different state to state? Are there states where the attorney general does have the latitude to pursue, to pursue corporate executives that are telling their workforce sales at any cost?
Right. Well, so you'd have to probably show that they were being deceitful. You'd probably have to show, but that wouldn't be hard, would it? Not in this situation. You'd probably have to, there are certain things you'd have to prove, but states like New Jersey has plenary authority, criminal and civil. I think the same in Delaware. I think the same in Rhode Island. And there's a few other states that have equal hand criminal or civil. Most states will take, the attorney general will have civil authority in general, and the local district attorney or county attorney and the U.S. attorney will have criminal authority, but then the AG can be like the prosecutor, criminal prosecutor of last resort. So that's kind of how it is in Minnesota. And I think that's the main model. I wouldn't say that we have wildly different authority.
Yeah.
Everybody has some sort of a unfair and deceptive trade practice, some sort of a prohibition against false advertising, against unfairness, which is defined within the law, fraud, misrepresentation. These things there is a body of law that is substantially similar. Some words are different than others. I know that in Michigan, this legislature passed some law that prohibited the attorney general from suing pharmaceutical manufacturers, which is extremely curious. Wonder how that happened. Wonder who was behind that, but I mean, but in the main, so here's the good thing. So the attorney general, Dana Nessel in Michigan, was able to opt into the settlement, but she could not initiate it based on Michigan law. But most states do have, the AG has the authority to dive in.
Okay, thank you. We got just two more and we'll let you go. So one is back to this issue of privilege, and one of our, someone that's joined us writes, there's clear evidence in industry documents that tobacco companies started deliberately routing reports via external lawyers to claim privilege. Do we know if opioid vendors have done this? That's a bit technical. I don't know if you know that, but I thought I would do the person a favor and pass it to you.
You know what? I'm a little embarrassed that I don't know the answer to that question. It wouldn't surprise me if the answer was yes.
Right.
But that's one where we need to dig into the archive and see for ourselves.
Right.
And I'll take that back and see what I can find out.
Okay. And then the last question is forward-looking, Attorney General. It's not really precisely about document disclosure, but we have you here, and this is about the future as well as the past. And it's a question, I'll just read it verbatim. John Oliver made a piece last night about how the money received from opioid settlements was being spent. Do you have programs in place to regulate how the money will be spent and roadblocks to prevent it from being spent by they say special interest groups like law enforcement. I'm not sure I would think of law enforcement as special interest necessarily, but in any case, that's the question.
Yeah, you know what, to tell you the truth, Dr. Alexander, one of the problems I encountered just this weekend is that sometimes the rules on expending the money are so tight that some law enforcement people and local community health leaders have found them a little too restrictive. Right. We may need to revisit them. I think that everybody is on alert for fraud, misuse of funds, and nobody wants to see that happen. So I think that we're going to have to continue to work this thing as we go. Yeah. Because we don't want the program to be so restrictive that like a high school counselor can't get into education program in the local high school. Or has to jump through 50 red hoops before they can do it. But I will tell you that, in Minnesota, we have a number of prescriptions, and in the settlement documents, those prescriptions exist as well. But we're going to have to stay vigilant to make sure that the money is getting where we want it, which is where the pain is, which is in the local communities, which is with the health professionals. And again, which is with I think I agree with you. There are a lot of people in law enforcement who are actually true allies in this fight and see it every day as first responders. So that would be my answer. I think we've got good things in place to stop fraud, but I'll just add this one thing. In my 5 years of being Attorney General, I am at least once a week shocked by the ingenuity of a fraudster. These guys are good at crime. I wonder what they would do if they put their mind on actually something good. You know, it'd be amazing. Well, thank you, Dr. Alexander, and thank your whole team. Consider me a friend ongoing. This is not just a one and done. We're in relationship now, and we need to stay in touch. And just remember, don't assume Attorney General probably already knows, because there's a very good chance they don't. Give them a call, let them know. And then the worst thing could happen is now they know twice. So there you go.
Thank you so much. We really appreciate it and wish you the best. Thanks again.
Likewise. Bye-bye now.
Bye-bye. Thank you to all. And at this point, we will pause for 1 or 2, maybe just 1 minute or less, and I'll hand the baton over to Adam Koon. Let me remind those of you that joined us since the outset that next we'll have a panel. And I just want to acknowledge our 3 speakers, Adam Koon, an assistant scientist at the Johns Hopkins Bloomberg School of Public Health, and Aaron Kesselheim, professor of medicine from Harvard Medical School, and Regina LaBelle, director of the Addiction and Public Policy Initiative at Georgetown University Law Center. Adam, the floor is all yours.
Great. Thank you, Caleb. And thank you to Attorney General Ellison. Those comments were very provocative, and I'm looking forward to the discussion that we'll move to today. So we're going to begin with Dr. Kesselheim. And just a reminder, like the previous session, it would be very helpful for the discussion if you could insert your questions in the Q&A function through Zoom. So first we'll have Dr. Kesselheim, and then we'll move to Regina LaBelle, and then we'll open it up for a broader discussion. So over to you, Professor Kesselheim.
Thank you, Adam, and thank you, Caleb, for organizing this and inviting me. Thanks to Attorney General Ellison for a great talk and a great hour. Very educational, certainly tough to follow that, but I will try. So I am going to talk a little bit about the importance of product liability litigation and litigation document repositories in safe drug use. And so as Caleb said, I'm a professor of medicine here at Harvard Medical School and Brigham Women's Hospital. At the Division of Pharmacoepidemiology and Pharmacoeconomics, I run a research center called Portal, or the Program on Regulation, Therapeutics, and Law. We are an interdisciplinary research center that focuses on the intersection of medication use and development, and some of the legal, regulatory, and economic issues that relate to the pharmaceutical market. So we have about a dozen or so faculty members and postdocs and research assistants, all told in our group, which makes us one of the largest and most prolific non-industry funded research centers in the country that focuses on this area. And so neither myself nor anyone in our group has any personal financial relationships with the pharmaceutical industry. And we get our research funding from various public and nonprofit foundation sources that you can see listed below. And in terms of disclosure, I want to say that I acted as an expert witness in a case on behalf of the state of West Virginia in litigation against opioid manufacturers related to their promotional practices. So my goal over the next, in presenting my initial remarks over the next 15 or 20 minutes, is to talk a little bit about how information comes to light about safe prescription drug use, and then talk about the role that product liability litigation plays in helping support that outcome, and the role that document archives and document disclosure, like the ones that we're talking about today, can be used in defining drug risks. So just to set a little bit of groundwork here, in order for drugs to get approved by the FDA, there's basic statutory efficacy and safety requirements that must be met. And usually those are met as a result of clinical tests that are performed both in the laboratory in animal testing, and then in human clinical trials in order to demonstrate that a drug has sufficient efficacy and safety to be approved. And in order to be approved, you have to show that your drug has substantial evidence of efficacy from adequate and well-controlled studies. And you have to show that those studies that you do show that your drug is sufficiently safe for use. And then the FDA evaluates the benefits, evaluates the risks, and will approve a drug if it appears at the time the drug is approved that the benefits outweigh the risks of the drug. And so the stepwise testing of investigational drugs through phase 1 trials, phase 2 trials, phase 3 trials that I'm sure a lot of people have heard of, the whole point of that is to develop a record of drug efficacy in order to meet these statutory criteria of substantial evidence from adequate and well-controlled investigations. And at the same time that happens, the sponsors of these trials are gathering safety information. The problem is that a lot of these trials have various limitations with respect to the safety information that is gathered. And that means that when a drug is ready for approval, first by the FDA, there can be a lot of holes in what we know about the drug's safety. So some of these key clinical trials that demonstrate a drug might work might also underrepresent certain populations like young people or older people or people with multiple additional medical conditions. They also might involve small numbers of subjects overall. They, maybe at the most hundreds or even thousands of patients. But then when a drug is used in tens of thousands or hundreds of thousands or millions of patients, there are side effects and adverse events for those drugs that can arise that we would have never known about even if we tested the drug in hundreds or thousands of patients before it's approved. It's also, when drugs are tested, they're also tested in a highly protocolized setting. Those clinical trials can involve short durations of testing, despite the fact that some drugs might be intended to be taken chronically for many years by patients. And then, there's oftentimes we're testing drugs against placebos, which is to say that to show that they're better than nothing, as opposed to better than other usual care that might exist. And the outcomes evaluated in these studies can be surrogate measures, laboratory tests, rather than actual clinical endpoints. So even though this testing is extremely important and very useful in determining whether or not a drug works, there can be important holes in the efficacy in learning about the safety of those drugs. And so in addition to that, not only at the baseline are there problems, but over the years, the FDA has accepted less and less data before a drug is approved as a basis for approval. And so the law allows the FDA to approve a drug on the basis of a single pivotal study. And if you look at comparisons in the quality and quantity of pivotal studies before a drug is approved 20 years ago versus today, you'll see that the efficacy standard and the amount of data that the FDA takes before it approves a drug has evolved quite substantially over time. And so it used to be that 80% or so of drugs were approved based on 2 or more pivotal studies. Nowadays, it's about half of drugs that are approved based on 2 or more pivotal studies. The number of pivotal studies that used an active comparator as opposed to a placebo or a historical control has fallen to less than a third of new studies. The amount of studies the amount of non-randomized or non-concurrently controlled studies has increased. And there is overall a greater reliance on these surrogate measures of efficacy, laboratory tests, rather than actual clinical endpoints. So not only is it that inherently the studies that we do to approve drugs are limited, but the number of studies and the amount of data that we collect on new drugs before they're approved has shrunk over time, which puts more and more pressure on our ability to collect safety information and more information about drugs after they're approved. And then I also want to make the point that not only all of that, there also are all of these expedited approval pathways that are becoming much more popular. And these days, over 2/3 of new drugs are approved through one or more of the FDA's various expedited development and approval pathways. And what that means, as you can see here, this is a study that we did, is that there is a greater number of drugs for which we learn about important safety issues after they're approved. And this was a study that we did comparing expedited approved drugs versus non-expedited approved drugs. And you can see there in the second row up from the bottom that there's about a 40 or 50% increased risk that those expedited pathway drugs will get a new boxed warning or contraindication after the drug is approved, indicating some of the most important safety issues that we might have. So the FDA has various tools that it can try to use to update and the safety information that we have about prescription drugs. The main way that the FDA does that is by collecting reports of adverse events about drugs based on their experience in routine clinical care. The problem is that there is substantial underreporting of these adverse events. Talk to any medical physician or other prescriber who and ask them how often they actually voluntarily report adverse events to the company or to the FDA. And the answer is almost never, despite the fact that drug side effects happen all the time. And so even though this is a major way that the FDA can learn about drug safety information, it is also not very. It's challenging for the FDA to do that because of the substantial underreporting of side effects. The FDA can impose and request that drug companies commit to doing additional studies after a drug is approved. These are called post-market commitments or post-market requirements. But again, there are important limitations in the FDA's ability to do that. The FDA can only ask that these studies be done to evaluate more safety related issues. It can't require phase 4 studies to test additional questions related to a drug's efficacy. And then I'll tell you in a second about the outcomes of some of these studies. There are other programs that the FDA has. The REMS program, or the Risk Evaluation Mitigation Strategy, is a special program that the FDA can impose on particular drugs with certain specific safety information to require additional testing or education of prescribers. But there's a lot of good work out there, some of which led by Dr. Alexander, about the fact that these REMS programs aren't necessarily followed up on as well as they should be by the pharmaceutical companies or acted on by the FDA when they get the information that these programs aren't fulfilling their goals. And then finally, there is the Sentinel system in which the FDA can access a lot of routine clinical use data. But after about 15 years in action, the Sentinel system exists and is there as a resource, but it still has not led to a large number of changes to drug safety labeling because they're still getting a lot of the methodology down pat and still figuring out how to best use it. So again, this system exists, but does not fulfill all the needs that we have for learning about drug safety issues. And this is just a piece of data about post-market commitments and requirements to show that even though there are hundreds of these post-market commitments that have been requested by the FDA, there isn't a lot of the drug companies don't have a lot of incentive to complete these studies in a reasonable period of time, and so a lot of them are completed late, and some of them may not be completed at all. At the same time that we have this initial problem with learning about a safety of a drug, and then these additional other tools that the FDA has that may not be well used to learn about drug safety. At that same time that's happening, drug companies are spending billions and billions of dollars, $20+ billion a year, marketing drugs to physicians to get them to be used as widely as possible. And that can include direct detailing to physicians, free samples that are given out for promotional purposes, direct payments, and so-called education through continuing medical education and other and consultancies with individual physicians of the kind that Attorney General Ellison was talking about, as well as direct consumer advertising. So at the same time that drugs are approved based on limited data, And we don't know a lot about their safety information at the time they're approved. And then we have a lot of these holes in collecting safety data. At the same time, their drugs are being widely promoted to be prescribed. And so this means that litigation plays a very important role as a drug safety information tool of last resort, because the FDA's greatest authority comes before approval, and drug companies have substantial incentives to try to encourage prescribing as well as broadly as they can. So what I want to talk about now for the last section of my remarks is to talk about how litigation does this, and what some of the roles that the document archives can play in helping support the ways that the FDA approval process, while essential, is also limited in some important ways. So first off, the major way that this kind of information is collected, these document archives is collected, is through product liability litigation, which can be an opportunity for individuals harmed by drugs to seek damages from its manufacturer. And product liability litigation can be based on a number of different theories. That it can be that a drug is manufactured improperly, or that it's designed improperly, but those kinds of arguments tend to be relatively hard to make for a drug that is approved by the FDA. Instead, most product liability cases are based on a claim that there has been a failure to warn about a particular side effect or risk of the drug. And making a case about a failure to warn involves three main contentions. First of all, that the manufacturer knew about a particular risk, that it did not sufficiently warn physicians or patients about that risk, and then that risk directly led to the damages that the patient had. So in terms of knowledge, the general principle is that manufacturers aren't liable for risks that they could not have known about. So in this case of Chambers versus Searle, for example, it was claimed that this oral contraceptive agent was argued that it caused stroke in patients, and what the court found was that there was evolving knowledge about the risks of this drug, and the manufacturer is only held to be aware of a fair representation of the medical and scientific knowledge available at the time that the drug was being used. But if there is knowledge about drug side effects, and the manufacturer isn't telling people about those, then that's where the problem arises. And by the way, that knowledge can be actual or constructive. So it can be actual knowledge that the manufacturers have. And so, as in the case of paroxetine, one of the antidepressant medications, where it was found that the manufacturer had withheld from making from communicating to physicians and patients about certain studies that it did that showed that the drug didn't work and had important side effects that were ultimately uncovered through an effort by New York Attorney General at the time. That's actual knowledge, right? So that's knowledge that the manufacturer had that it wasn't communicating to patients or physicians. And then there can also be constructive knowledge, which is knowledge that the law assumes to be present even if the manufacturer doesn't appear to have it. So if there is a drug that is causing bad side effects out there, a manufacturer can't simply put its head in the sand and say, "Look, I'm not responsible." In fact, by virtue of selling the drug, they are responsible for having a reasonable knowledge of the side effects it causes. And so, in the case of cerevastatin, or a dangerous cholesterol-lowering medication that was approved by the FDA and caused liver failure, there were these reports of people with these bad, sort of substantially elevated liver function tests, and the manufacturer had a responsibility to have knowledge about those side effects and pass them on, and then take appropriate action. In addition to that, the warning that's provided to the public has to be adequate. The warning has to be commensurate with the scope and extent of the dangers. So in the case of troglitazone, a diabetes medication, the manufacturer warned about increases in liver function tests, but in fact knew about some liver function test increases that were so severe that they would cause liver failure. And so, a sort of bland warning about the potential for increased liver function increases is not allowed, but is should be there. There's needed to be a greater warning about the very serious risks of this drug. And then a warning must not be subject to undue delay, as in the case of Propulsed, a GI medication for which the manufacturer and the FDA negotiated for 5 years over how to change the drug's label to include safety data. That was an unreasonably long period of time for there to be no public information about the cardiac side effects of this drug. And so, again, when a manufacturer is providing warnings, it has to provide them in a reasonable period of time, and it must be of sufficient urgent tone, as in the case of rofecoxib, where manufacturers kind of underplayed or downplayed the cardiovascular side effects of this drug. And then finally, you have to show that the product caused the injury, both in general and specific for the patients. Of course, there are different views of causation when you think about, scientists or pharmacoepidemiologists think about causation, at the level of a statistical association where the null hypothesis can be, the null hypothesis can be excluded in less than 5% of the time, as opposed to legal causation, which is a clear chain of direct impact from one or the other. So these are the responsibilities of the manufacturers. And, unfortunately, and not just in the opioids case, there is a long history of manufacturers not living up to these responsibilities. And that's where product liability litigation can be very important, and can lead to information that can help bolster the safe use of drugs. And that is exactly where the OIDA and document discovery like it can be very important, because, as when we're going through these kinds of evaluations, if there are, specific issues that come up in any of these areas, like I've discussed, that information needs to become public, and it is through making that information public and available in document archives like OIDA that we can really affect change. And so, and we have seen that come up numerous times over the course of the last couple decades, not just in the opioids case, but in dozens of other cases like it. So the information that arises as a result of product liability litigation can expand drug safety knowledge in a number of different ways. You can make public data on risks found in pre-approval studies. So these are risks. In this case of valdecoxib, there was data that was collected by the manufacturer before the drug was approved that the manufacturer never made public, came to light as a result of product liability litigation that led to the information being that led to the manufacturer being forced to release that information so that we could learn more about the safety of this drug, which was eventually pulled off the market. Releasing data can also help ascertain post-market safety events. So in the case of the antipsychotic medication olanzapine or Zyprexa, there were studies that emerged a few years after its approval linking its prescriptions to weight gain and diabetes. And ultimately, the information that came to light as a result of patient-initiated lawsuits led the FDA to learn about this information and to do more formal analyses of it, and ultimately to require more prominent warnings about diabetes-related adverse events be listed on the side effect. And ultimately, in this case, in this olanzapine case, also the settlement process required that the documents revealed during the discovery process were made public, and to help educate prescribers about this issue, which I think impacted the prescriptions of these drugs. And we already talked about the antidepressant paroxetine or Paxil, in which data about suicidality in pediatric populations in particular was not released. And ultimately, manufacturers, as a result of the litigation, were forced to release this information. Once that information becomes public, as it does in the places like the Document Archive, it can be used to help change labeling and information and knowledge and prescribing. The other thing, and again, Attorney General Ellison pointed some of this out, is that the other thing that this litigation can do is reveal manufacturer strategies and practices that undermine safe drug use, like the dodgeball and other strategies that the manufacturer of rofecoxib used to distract physicians from the potential cardiovascular risks of that medication. And then we also talked about the triglyceridone case and how the data were reported in ways that didn't fully reveal the risks. And so again, it just kind of points to strategies that manufacturers can use to underplay data, to underplay risks. And in that case, what they did was they merged all the even the sort of not very clinically significant liver function abnormalities with the very clinically significant liver abnormalities in order to underplay the liver side effect risk of this drug, which ultimately ended up being pulled off the market. And then finally, it can lead to changes in FDA policies. And we talked about the cisapride case, but Paxil is another one, and metoclopramide or Reglan. All of these have led to to encourage the FDA to do more formal studies of the issue, and ultimately to lead to boxed warnings that can help change prescribing practices, or to try to give the FDA more. To try to get the FDA to advocate with Congress so that it has more authority to make these changes itself, or to try to move ahead on changing labeling without having to have drawn out discussions with the manufacturers behind the scenes. Overall, then, so the role of drug litigation data in promoting drug safety is to supplement the FDA's inadequate resources and incentives to monitor the market for the performance of all drugs, and to supplement the information that is lacking in some of the early clinical testing that is done on drugs, and some of the post-market oversight that is done as well. Information like the kind that's in OIDA has enabled reassessments of drug risks by better evaluating existing data. This information the availability of this information also provides a strong incentive to manufacturers to change their practices and to be more forthcoming about evolving health risks related to their products. And then, of course, one of the most important things that product liability litigation does is it provides consumers with recourse in the event of that all of these kinds of behaviors and issues lead to bad patient outcomes. So those are my comments, and I look forward to hearing the rest of the panel and having a conversation about these issues as well.
Thank you very much, Dr. Kesselheim. I think that this is really helpful background, which will be useful as we're thinking about as we move to Regina LaBelle's presentation. And just a reminder, we've had 2 great questions in the Q&A. Keep them coming. We're going to respond to them after Regina's presentation. We'll move into kind of the last 30 minutes where we'll have a rich discussion about some of these things. So over to you, Regina.
Great. Thanks so much. And I'm going to share my screen. Thank you so much for having me here today to talk about this. And I so appreciate the documents and the rich information that is available. And if I can get this to work, sorry, I may have to stop again. Apologies. And go back. Okay. So what I'm going to talk about is what I want to talk about today are the policy implications of the information that was contained in the document archive. So I want to talk about the law, policy, and lessons for the future, because there are some implications for the future as we see the opioid and overdose issue morph. There are a lot of changes to policy that need to happen, and some of the document archive can really prove helpful for that. So I have no financial disclosures to reveal. I work at Georgetown
Regina,
University.
just one moment. If you're trying to share them in full screen mode, we can only see the slide outline mode.
Right, and I know, sorry, it's not working in full screen, but let me see
That's
if I
fine. You can proceed as is.
let me see if I can do that. Okay. Sorry, it's not working.
No problem. Let's move forward.
Operator error, I'm sure. Apologies. So I'm at Georgetown University's, I split my time. I'm at the Addiction and Public Policy Initiative at the O'Neill Institute, which is at the Law Center. And what we do there is we advance public health efforts to improve the lives of people with substance use disorder along the continuum of care. We do quite a bit of leadership development for and with individuals in recovery or who have otherwise been affected by the overdose epidemic and addiction generally. I also teach and direct the Master of Science in Addiction Policy and Practice and the Graduate School of Arts and Sciences at Georgetown. This is a unique program where we combine the science of addiction with policymaking. So when students leave, this is our third cohort who's about to graduate. When students leave, they're prepared to hit the ground running to advance evidence-based addiction policies. So they don't only understand the science of addiction, they also understand kind of the nitty-gritty of policymaking. And so again, we have our third cohort about to graduate in July. So I want to talk first about the current state, and I'm going to talk, I know the Attorney General touched on some of the data, but I think it's really important to put this in context. And, this dialogue and the information that is contained in it, it's really all about the lives of people we've lost over the last 2 decades now. And so I want to talk about the current state of the overdose epidemic, where some policies have been implemented to change what we experienced, and then going forward, some lessons for the future and recommendations. So we're at, and we've been over 100,000 deaths every year for the last 2 years. These data lag, unfortunately. So the 12-month period ending in November 2023 still shows that we're over 100,000 people who die from an opioid-involved overdose every year. Now, it's primarily driven right now by illicitly manufactured fentanyl, but we're not reaching, while we may have leveled off some, we're not bending the curve as we should be on this issue. This shows, again, where we are in terms of the rates of overdose deaths. Now, you'll see most of the states east of the Mississippi have either had a leveling off or a decrease in overdose deaths. And much of that is due to the fact that fentanyl was really introduced west of the Mississippi later. There's a number of reasons for that: drug trafficking networks, as well as illicitly manufactured fentanyl availability came a little bit later to west of the Mississippi. Now what we're seeing west of the Mississippi are pressed pills, mostly coming over the border, containing illicitly manufactured fentanyl. And that's what's really driving overdose rates of death across the western part of the country. So when we talk about overdose deaths in this country, the 2014, 2015 really marked that transition between prescribed opioids, heroin-involved overdose deaths, and that's when we started seeing the increase in illicitly manufactured fentanyl deaths. And that we talk about this in 3 waves, and some people talk about a 4th wave involving polysubstance use and stimulants. But really what we're talking about today and what this archive discusses is that 1st wave, is that rise in prescribed opioid overdose deaths that started in the 90s, driven by OxyContin, and that there's such a plethora of information in the archives. It's somewhat overwhelming, but there's been so much good work, so much research, so much journalistic excellence that's gone into exposing some of the marketing practices that we saw at that time period. Then again, wave 2 was the rise in heroin overdose deaths, which really was swiftly overtaken by synthetic opioid overdose deaths, and that mainly involving illicitly manufactured fentanyl. I have this slide here because I think it's really important that we think about the bow wave of the communities that have been affected. And these are children who lost a parent to drug overdose deaths. This research was just issued last week, just released last week. It was in AMA Psychiatry. It was 300,000 children lost a parent from an opioid-involved overdose death from 2011 to 2021. The research was just issued, as I mentioned. It was led by Dr. Chris Jones, who's with SAMHSA, as well as other researchers in other SAMHSA, as well as in the National Institute on Drug Abuse. But it's really important that we not think about these issues as just historic. These will have implications for decades to come. And so as we saw, the high watermark, we're hoping it's the high watermark. But these children are left behind as a result of opioid overdose involved deaths for the last decade. So, attorneys general, lawyers like myself love this phrase by Justice Brandeis. I know that the Attorney General shared it earlier today about how sunlight is the best disinfectant. And that's the beauty of this archive, of all this information. And if you ever think that, ever want to be reminded of the marketing playbook, the marketing practice, just take a look at a few of these documents. And I know that many of you have. And it is so important that we were able to have these documents as a result of a lot of heavy lifting by attorneys general, by journalists, by Johns Hopkins, UCSF. And I'm really just, it's just an incredible opportunity to have these archives. And I'm also reminded of this Lancet series that was just issued, came out last year, about the commercial determinants of health. Relatively new terminology that's applied to this. And Lancet describes it as systems, practices, and pathways through which commercial actors drive health and equity. Now, they can drive health and equity in negative ways, which is really what we saw a lot of with opioid manufacturers, distributors, pharmaceutical manufacturers. It can also drive negative health outcomes and equity, as well as positive. So this commercial determinants of health really underlies a lot of the ideas and the research and policymaking that we can use moving forward. So what I want to talk about now are some recommendations for legislative and regulatory actions, but also highlight a few actions that have recently been taken. So first, conflicts of interest. And this is kind of a theme running through a lot of the, certainly the McKinsey litigation that was brought against the McKinsey consulting firm about contracts and transparency. Now, this graphic is from the Washington Post, but it also highlighted a number of pieces that came out about the Food and Drug Administration interaction with McKinsey. So at the time, McKinsey was not only contracting with the Food and Drug Administration, it was also contracting for a time with J&J and then with Purdue Pharma. And if you look through the document archives, you'll see the extent of the work that McKinsey did to do the playbook, to make sure that the playbook of Purdue Pharma highlighted, expanded their sales practices, and also to help them pivot to new markets. And there was actually in the McKinsey document archive, it talks about how McKinsey was talking to Purdue about how to get involved in addiction treatment and promoting addiction treatment medications. So the US Senate and House, this was a bill that passed in 2022. And what this did is it prevented those types of conflicts of interest, so that you would actually have to reveal if you had a contract that could be a conflict of interest with your advice that you were giving to the federal government. So this did pass both houses, and the president signed it in 2022. That's one reform that came about as a result. There was a investigation that came about in the House about the McKinsey contract, but it was able to use a lot of the documents that were in the archive. And marketing practices, this is another central theme of the documents that are in the archive. There are two pieces. So marketing practices, the first part is transparency. And this document here, it's openpaymentsdata.cms.gov. Now, the Open Payments Database did not come about as a result of the litigation. It was part of the Affordable Care Act. However, what it does is it allows for journalists, researchers, and others to look up a doctor and identify whether or not they've taken pharmaceutical manufacturing money or other industry funds. It's not used as much by consumers as perhaps it could be, but certainly its benefit is to see, so that you can see. It's again about transparency, and the transparency really relies upon the data being put into here. There is a data lag, so it's about a year. So you wouldn't be able to go in and see in real-time information about whether or not a prescriber or a doctor or other is taking funds from a manufacturer, but at least it has that information over a longer period of time. Now, the second piece of marketing practice reform that's been put into place, and this is courtesy of Farmed Out. Farmed Out is an entity that's run by Dr. Adrian Few Berman, who is a colleague with the Georgetown University Medical Center. And they do a lot of research on the influence of pharmaceutical practices in the practice of medicine. And so they've done a review of state and local laws that have attempted to rein in and reform marketing practices. So the first one is drug rep licensing. So the District of Columbia was the first one to have, you have to license. If you're a drug rep and you're going to go into a doctor's office, you have to get a license with the District of Columbia, Chicago, and the state of Oregon. The second is the gift ban. So this is obviously a ban on gifts from pharmaceutical industry representatives. And this is in Massachusetts, New Jersey, Vermont, the District of Columbia, Minnesota, Maine, California, and Wisconsin. So I want to, Dr. Few Berman told me a little anecdote about this. She went to a conference in Massachusetts, and they had a big espresso machine, but they had a big sign on it that said, because it was a pharmaceutical company that was going to provide the espresso, said if you're a prescriber, if you're a doctor from Massachusetts, you're not allowed to get this espresso. So these gift bans have been put into place with a lot of backlash or opposition from industry players on this issue, but they've been able to do it in several states. And lastly, transparency laws. So again, transparency is the ultimate disinfectant. Connecticut, DC, Massachusetts, Minnesota, Nevada, and Vermont have put in transparency laws so that journalists, researchers, and consumers can know if a doctor, if a prescriber is getting funds from a manufacturer or another representative of the pharmaceutical industry. Now, those are the reforms that have been put into place. And I want to talk about a few challenges that we're facing right now. So there are 3 FDA-approved medications to treat opioid use disorder. 2 of them, methadone and buprenorphine, are opioids themselves. So one of the reforms, one of the laws that has been put into place is in many states and on the federal government are red flag laws and suspicious order requirements. Now, this means that the purpose of these laws is to prevent what happened in small towns where they were just deluged, the pharmacies were just deluged with opioid prescriptions. The point of this is to alert regulators, but also the pharmaceutical industry to what might be a suspicious order. But what's happening with red flag laws and the suspicious order requirements is that they're having a chilling effect on buprenorphine availability. Both the prescribing of buprenorphine, the dispensing of buprenorphine in pharmacies, as well as the stocking of buprenorphine. Because pharmacies are concerned about hitting that suspicious order requirement. And if they have a red flag or they have an alert about a suspicious order issue, it could bring the Drug Enforcement Administration to their attention. And that is the concern. We have heard this over and over. So what is happening right now is that the Drug Enforcement Administration has put out a Q&A on this and said that the intent is not to make people not stock or provide buprenorphine with a valid prescription. The intent is to make sure that they're paying attention to suspicious orders, which is they're required to do under the law. Recently, on May 10th, several entities, including the American Society of Addiction Medicine, the American Medical Association, wrote to the administration, wrote to the Drug Enforcement Administration, asking for further clarity on this. Now, we know that there is prosecutorial discretion, as well as the Drug Enforcement Administration has special agents in charge across the country. And so they may look at these laws in different ways. So the American Medical Association, the American Society of Addiction Medicine is asking the Drug Enforcement Administration and other members of the administration to clarify these red flag laws for pharmacies so that there is adequate availability of buprenorphine. Also, the Federation of State, the National Association of Boards of Pharmacy is also putting out rules and regulations that would clarify this for pharmacies and pharmacists as well. Now, I raise this not only because of the importance of buprenorphine availability if we're going to curb overdose deaths, because it is the standard of care. Medications are the standard of care for opioid use disorder. But I also raise this for implications for methadone reform, because there is reform legislation before Congress. I don't know if it will pass this year, but if it does, it would allow, if you're an addiction medicine specialist doctor, you would be allowed to prescribe methadone and have it picked up at a pharmacy. Right now, opioid treatment programs are the only entities that can dispense methadone. So this would expand access by allowing it in pharmacies. But if these red flag laws and suspicious order requirements are not addressed, this could have great implications for that reform and availability of 2 of the 3 medications that are the gold standard of care for opioid use disorder. So I raise that because every time we have a reform, we also have to think about the broader implications across the policy arena. And also I want to talk about, briefly leave you with one area that I think is really important as we're talking about the commercial determinants of health, as we talk about the importance of legal entities looking into the commercial determinants of health. I think one area that all of us need to pay very close attention to is gaming and gambling, and the expansion of the gaming industry, the expansion of gambling across the country. And I truly believe that if we looked at their documents, if we had access to their documents, we would find these same exact things happening in that industry. And so I would recommend that if I were, advising Congress, that they look at this now. There is legislation pending. Look at this now to make sure we're regulating, but also at the state level. Make sure we're not waiting too long, like we did with tobacco, like we did with opioids. Don't wait too long, and then we have to react. And then finally, I want to, this is my contact information. And as Caleb did at the beginning, I appreciate, remembering the lives lost. This is in memory of Charlie Nichols, who was the nephew of a good friend of mine. With that, I'll turn it back over, and thank you very much.
Thank you, Regina. And so now we're going to move into that was a very interesting presentation. And I can't wait to kind of pick apart some of the things that you both have identified in your presentations. So this is just a reminder that we're fielding questions in the Q&A. And to get things started, I have a question for Dr. Kesselheim. You mentioned that the FDA has relied less and less on research from pharmaceutical in pharmaceutical approvals, and increasingly on surrogate efficacy measures and allowing for these expedited approval pathways. We've seen evidence of that, particularly in the new drug approval applications that for prescription opioids that are located in OIDA. They're written very vague, and the science is presented as kind of consensus, when in actuality, the science was very much evolving and formative at that time. But may I push you a little bit further? Why do you believe that we're seeing this trend at the FDA, or that we have over the last couple of decades? And is there anything that advocates, researchers, or others using OIDA can do to change this trend?
Thanks, Adam. It's a good question. I think that there's a lot of different reasons why we're seeing this trend. I think that first off, it is the case that the drugs themselves, there has been an evolution in the kind of drugs that the FDA reviews. 20, 30 years ago, there were a lot more drugs that were intended for broader populations. And now there is a greater number of drugs that are intended for rare disease or that are intended for diseases caused by specific genetic alterations. And for those reasons, there could be many legitimate scientific reasons why you would want to have a trial developed a certain way. That being said, I think there are also a number of other reasons because I think that the level of changes and evolution in the data that are collected for drugs before they're approved cannot fully be explained by those kinds of changes. I think it's also an effect of a couple decades worth of advocacy by the pharmaceutical industry and the patient advocacy groups, many of which get a lot of their funding from pharmaceutical companies that have pushed the FDA in the direction of seeking less and less data and less rigorous trials before drugs are approved. So I think that's another component. And I think that a lot of the things that I mentioned about the weaknesses of pre-approval trials are on full display for drugs, for opioid medications. A lot of those are approved based on short-term studies with very small selected populations. And then the idea of longer follow-up is left to the post-approval period, whereas I talked about as well, there are a lot of holes. So I think that there are things that folks who are interested in this area can do to try to raise this issue. I think that first off, using the archive and using the materials that are collected in studying these kinds of trends and in bringing them to light can be very effective in helping add to the conversation around this area. I think that talking with your representatives and being politically active and advocating for positions that would help provide allow there to be a strong FDA and to give the FDA sufficient authority to raise to require the evidence that is needed is also important. So I think those are some of the things that people can do.
Great. And if you had a magic wand at the FDA, to Antoine Lentacker's point, what would be some of the smaller measures that you could take to better protect patients?
Let's see. What would be some of the immediate things that, like,
Yeah.
I just read the question in the Q&A. So I'm sorry, Adam, what would be some of the things that I would do to try to protect patients in the short term?
Yes, in the post-market approval process or post-market surveillance or approval process.
Sure. So, well, one thing is that the FDA has the ability to fine companies that don't conduct their post-approval studies and don't do them on time. The FDA has never exercised that authority. I think that it is there might be an opportunity to have the FDA actually enforce the fines that it can impose. I think that the FDA needs more authority to take steps to enhance the labeling of drugs, and to withdraw drugs from the market. There is currently to withdraw a drug from the market is a very long and bureaucratic administrative process that the FDA has to go through. So there are ways that we can, you might imagine trying to think about how to giving the FDA in the short term more authority to be able to take steps like withdraw drugs from the market that it thinks are sufficiently unsafe. But I think that in addition to legal authority, I think it also takes culture and at the FDA and a willingness to do that. And I think that the FDA has, at the same time that it lacks the authority, has also moved away culturally from a lot of these kind of decision making as well. So I think that I think that requires some changes in perspectives at the upper echelons of the FDA. That's a little bit more challenging to figure out how to make that happen.
Great, thank you. And just a reminder that the Q&A is open for questions. We have at least one other one, but I want to move to Director LaBelle's presentation now. Regina, as you mentioned with the recent research on the impact of caregiving, that it's not just a problem with health or legal implications, but it's also one that concerns child social welfare. So it's somewhat unique, I think, in terms of policy issues that we have a dedicated office within the White House that addresses these things. And so I'm wondering, in your previous role as the acting director and before that chief of staff of the National Drug Control Policy, it would be good to know a little bit more about how document archives can shape policy guidance and the ability to frame problems in ways that resonate with broader constituencies.
Great question. I think that, so the Office of National Drug Control Policy is, as you mentioned, it's in the White House, the Executive Office of the President. I think people think it's a lot bigger than it really is. We had, about 67 people when I started. I think they have like 80, they're up to 80 now. So how it can be the best use of the archive is for journalists and researchers to take it and kind of pay attention to these things. Only because we had, the office is relatively small, and and the archive is so huge. So the challenge always is kind of identifying what are the most important items that you want to pursue from a policy perspective that you can get done in the period of time that you have. 4 years goes by really, really fast, that is achievable and that's going to make a difference. And, so I think that certainly there are experts across the federal government who will, advise on that and provide policy counsel and policy advice to my former office. But I think sometimes because the incoming is so much, that having people, experts, outside experts who can advise is also really important. And so identifying those policy changes that are doable, but will also have the biggest impact on these issues. And the commercial determinants of health, as I mentioned, is relatively, it's kind of in the nascent stages. I think we've always had it, but now we have a name for it. So identifying those areas that that office can have the biggest impact on is really important.
Great. Thank you. And also, Director LaBelle, one of the things that I know that your group has worked on a bit, and we've touched on, I think the Attorney General touched on it briefly in his comments, was the current allocation of state settlement resources. And I'm wondering is there anything that we can find from these public documents that can help inform adequate strategies or fair and transparent resource allocation approaches for states who may be operating oftentimes in the dark and with limited information about how best spend some of this settlement money?
Right. I mean, so as he said, the agreement that was reached, the settlement agreement identified with Johns Hopkins help actually identified, where the money should go. And I think we have to remember the documents can be helpful in terms of reminding people, while we have to take care of today's problem, the documents help remind us of where we've been and how we got here. And while there is not a one-for-one, illicitly manufactured fentanyl is, really a game changer in the drug supply. It is important that we pay attention to the drivers, and that we are mindful of the marketing practices that really preyed upon poor areas of the country, and so that those are items to keep at the forefront. So the funding, however, does need to be spent on things to take care of the problem as it occurs today, and that will bend the curve of overdose deaths, best bend the curve of overdose deaths. But also, I think that they're good to have. The documents are good to keep people, to keep before us how we got here and what the origin of the problem is.
Yeah, thank you. And there's also a couple questions coming in regarding conflicts of interest. One was by David Hart, was the first question, was asking about the revolving door between the FDA and industry, particularly on drug labeling, where there's oftentimes just false or inaccurate information that undermines the FDA process. The other one's asking both of you a little bit more about some of the conflicts of interest between McKinsey. So I don't know if you wanted to speak to that.
Go ahead, Regina. Do you want to talk about McKinsey?
Yeah, sure. Always happy to talk about McKinsey. So, I think it's hard to draw the one for one, that because this happened, this was the direct conflict of interest. And, ethics rules rely upon the appearance of a conflict as much as the actual conflict. So, the appearance in this case was that they were advising both. We don't know. I mean, we have to have a level playing field in our society, and people shouldn't have more access to information just because they, have more access, they have more money, et cetera. That's the whole basis of, ethics rules are supposed to be to level the playing field. So, the documents certainly show that so McKinsey never acknowledged wrongdoing. It was a settlement that was reached. So I think I'm not a court of law that could say, yes, there was this direct one for one, but the appearance of a conflict of interest in a democratic society where you have to rely upon people having a level playing field, that was really where the problem lie. And we don't know behind the scenes what information was shared. Again, McKinsey denies all of that. That was not something that was ever found in a court of law. But that's why Congress passed this law. There have been standards put into place for a really long time to bar against conflicts of interest. Anyone who's been in the federal government understands how seriously those things are taken in the administrative sector, administrative branch specifically. So that law that was passed was sought to strengthen it. But as far as a one-for-one, like I'm going to give you this example, I can't do that because they did not admit any guilt.
I don't think that McKinsey should ever be paid for by the U.S. government to consult with them. Like I can't understand why the U.S. government doesn't have the authority and the ability to get the information that it needs and to hire the people that it needs to be able to do that. So I'm not sure why we need to rely so heavily on McKinsey at the U.S. government. But you know, I haven't worked at that level of the U.S. government, so I'm sure that there are legitimate reasons. But there's a great book called When McKinsey Comes to Town that I would suggest people read. In terms of the FDA, you know, I think that the revolving door again is a kind of a nuanced issue. You know, when a person works at the FDA and gathers that expertise, and you know, it seems, you know, they should be able to. If they leave the FDA, it is natural for them to work in the pharmaceutical industry or the medical device industry, where they, you know, where they can apply the expertise that they've gathered in a different setting. It is reasonable for there to be good, above the board, transparent interactions between FDA and companies. I think it becomes a problem when the leadership at the FDA comes from the pharmaceutical industry, and particularly when the leadership leave the FDA and then immediately become, you know, get on the boards of directors of pharmaceutical companies. I think there should be a moratorium of at least 5 years before those kinds of things are allowed to happen. Those kinds of things would help promote a culture of trust and belief in the trustworthiness of the institution, even though I agree with Director LaBelle that it can be very difficult to find one-to-one relationships of specific types of direct abuse of power, or other things that can be attributed to that. I think that it is still part of the culture of the institution, and more importantly, it's a part of how the public views the institution as well. So I think all of those things are important to think about when you think about those kinds of issues.
Yeah, go ahead.
So I think, you know, when we talk about this, one thing the document archives show also is the challenges with the revolving door at the Drug Enforcement Administration as well. So people were leaving the Drug Enforcement Administration and going to work for some of the very companies that they used to regulate. And that is something that, you know, has been pointed out again and again as, you know, very problematic. And so it's not limited to the Food and Drug Administration. We do see it across the board, not just Drug Enforcement Administration either, but the Department of Justice as well.
That's interesting. Yes, we have largely been talking to the FDA, but there is a whole regulatory apparatus, and there's also a variety of actors which are less visible. Oftentimes, as the next question in the Q&A gets at, there's a variety of trade associations who have operated in this space, and you can see it, evidence of it throughout the document archive, whether it's sponsoring continuing medical education courses, certificates, textbooks, etc. This person in the question is in the Q&A is asked whether, you know, that these trade associations are oftentimes tax exempt, and yet they manipulate scientific information pretty strategically. Is there any leverage to challenge the legitimacy of these organizations?
I don't know enough about the tax law to be able to comment one way or other about what kinds of behaviors they might undertake that would challenge their tax exempt status. So I don't know if I can address that part of the question. But I do understand where the question is coming from, and you know, there is a lot of history of professional societies and other trade organizations, physician organizations, industry organizations, patient organizations that have gotten involved in ways that manipulate the data. And I think that what this does to me is it calls for, you know, the need for a greater investment in neutral, unbiased sources of information that can be, where there can be, you know, trust and reliance on that kind of information. You know, part of the reason that those organizations have the ability that they do to have those kinds of, to issue clinical practice guidelines or influence clinical practice like they do is because there is no, the government doesn't currently invest in unbiased sources of information for the market. And so I think that the best way to try to reduce the influence that those kinds of organizations have on the generation of information is to generate more useful, unbiased information from alternative sources. And again, I think that the kind of information that is found in these kinds of in the OIDA and these kinds of archives can be a useful adjunct for that.
Great. One of the things that we do, that the archive, you may be wondering if you've attended this session today, who the actual archive is. It's a lot of archivists, computer scientists. So we are not advocates. There are a few researchers attached to the opioids industry document archive, but we largely see our role as kind of a public good, like a lighthouse or a fire station, holding these documents accessible to all, including industry, in perpetuity. And a lot of the job is full of minutia of how to digitize them, how to redact private information, and how to get the documents that come from the court settlements into a state in which they're usable. That said, I do wonder whether advocates are reading these, and advocacy depends on developing a strong message for change that draws on emotions, and there are a lot to get emotional about. We've discussed about in these documents. So if you both could reflect on the utility of these documents and advocacy efforts, what would be some ways that advocates could get involved, or obviously they can reach out to the archive, but what are some of the potential for archives like these and public documents from things that have happened in the past to affect policy moving forward in the future?
So if I could go back, as I said in my remarks about Adrienne Few Berman's work with at Georgetown Medical Center, she actually, she's an advocate on, she and her colleagues are advocates on, influence, pharmaceutical industry influence in the practice of medicine. So she relies on these documents a lot for her work. And she does try in her work, so it's just an example of what advocacy groups could do. She relies on the information that's in the document archives to drive, her blog posts, to take examples of what's available in the archives and use it to identify why something is needed. So when I went over the, specific transparency laws that have been input into, state and local governments, they're not a big organization and they're up against a lot of industry players, but those storytelling, and I'm not great at storytelling, but the storytelling that's available, advocates can really use that to overcome that industry influence. And, to talk about the quotes and there's such a richness in there. Now that can be taken out of context at times, but advocates can use it to drive change if they are using it as part of the narrative to explain why the reforms they're discussing are so important. And also how we should be looking around the corner. As I said, these industry activities are not, they didn't make it up. There's a playbook and it will be used again and again. And as you said, Adam, industry has access to this. So, what can we expect going forward in the future, and how can we use it as an early warning system for the future? Advocates can use it for that as well.
Great.
I guess I agree with all that. I think that if maybe one other potential area or a way of using this is, here at Portal, we're not advocates. That's not our role. We're academic investigators and researchers. But that also doesn't mean that we sit in our ivory tower and don't try to interact with policymakers based on the research that we do. And so, our approach here at Portal is to publish research and push that research out and talk about it with the policymakers and legislators and at the federal and state level. And we've had some, it's a challenge, but we've had some successes in using that to stimulate and generate policy change. And I think that the documents in the archive that you're talking about are an incredibly rich source of qualitative research that people can do on this case and use that as a basis for studying different issues and publishing those and getting those out there so that policymakers will read it and see it and use it as the basis for future change. And I think that there's actually, a lot of experience with that, having done that in other cases of, the Vioxx case and the Olanzapine case and, other cases in the past where there's been information that's come to light and researchers have used that information to, in analytic work, and that can be very powerful in helping drive policy change.
Great. And kind of on that note of transparency, this last question here asks about whether or not this could be a springboard to kind of more proactive kind of disclosure of data and information sources. And the questioner is getting at the fact that the data that we get, the documents in the archive are specifically geared towards breaking laws. They're very partial, very selective, tied to the narrow peculiarities of the lawsuit. But is there any barriers towards other efforts to be a little bit more proactive in transparency initiatives, such as, making pre-approval clinical trial data more accessible, or the DA's ARCOS database data more widely known and usable? Can you see anything wrong with that, for example?
No, I think that the FDA, we've been pushing the FDA for multiple years now to try to be more transparent about some of the information that it receives. And, I think that, more lawyers like the ones that were involved in generating this opioid document archive, I think that other lawyers that running large, product liability class action suits should think about the public health impact of having the data that they discover or the files that they discover be available publicly. Unfortunately, a lot of lawyers don't think like that. They're thinking, more narrowly about the specific case and the clients they're representing. And so, the vast majority of these cases is, the information ends up being sealed as part of a settlement. So yeah, I think that proactive thinking could be very useful, both at the regulatory and government level and also at the litigation level.
Yeah, I think showing examples of how it's been used is, can help, think about this and make sure that litigators are thinking about it. But also on the federal level, I think, we assume that every agency has access to every other agency's information, and that's not the case. It's not always the case. Sometimes these are proprietary databases that are paid for by that agency, and it would cost more to have it shared with another agency, which sounds crazy, but that's exactly what happens. So, number one is to make sure that information sharing is prioritized, but that also means that it has to be backed up and there might be money involved. So you have to ask Congress for that funding to make it so that it can be transparent to the public as well as to the entire federal government partners.
That's great. Well, thank you both. I think this has been a rich discussion. As we kind of wrap things up, we've had a nice 2 hours and change of discussion today, but is there anything that you'd like to leave us with for future thoughts or something that we haven't covered that you think should be better known in kind of the opioids health policy and law space?
Making sure that we
Go ahead.
I'm sorry. I think just making sure that we realize this isn't just isolated to opioids, opioid manufacturers, distributors, et cetera, that these are playbooks that we need to pay attention to and, you know, and look around the corner to what the next problem is going to be.
Yeah, and I just want to say that, like, you know, I think that it is remarkable what has been built with OIDA, and I'm, you know, extremely grateful to the folks who are behind it and who have helped, you know, generate it both on the lawyer's side and on the administration side in terms of making it available. It is a great model for what we could do in the future, and you know, I think that it would be great if this was used as a model for subsequent, you know, document disclosures.
Great. Well, thank you very much, Director LaBelle and Professor Kesselheim. This has been an illuminating conversation, and we've appreciated having you today. So back over to you, Caleb.
Thank you so much. We will wrap things up, and Adam, Aaron, and Regina, thank you again for your thoughtful discussion and contributions to today's session. I also want to thank all of you that joined today, and to remind you that if you have yet to browse the archive, we welcome you to do so. Again, we are fortunate to have an incredibly talented and experienced team supporting OIDA, both at the University of California, San Francisco and at Johns Hopkins University. And if we can be helpful to you in understanding how the archive may serve your own needs, please let us know. Again, the best way to contact us is through the contact information on our website. Finally, I'd like to remind you that our symposium will continue tomorrow from 12 to 2:30 p.m. Eastern Time, focused on information science. And so if you're wondering what information science is or how it's applied to an archive such as this, tomorrow is your unique opportunity to find out from some of the best experts in the field. And then we'll conclude the symposium on Thursday, May 16th. So we'll take a day off and then meet again on Thursday, May 16th, also from 12 noon to 2:30 p.m. Eastern Time, with a final session focused on the history of science and medicine, again, as it applies to the Opioid Industry Documents Archive. So thank you again to all of you for joining us today. This marks the conclusion of today's events.